Welcome to our continuing YouTube video series on employment law. My name is Christopher Neufeld of Neufeld Legal. And in this particular YouTube video, we will be discussing the importance of distinguishing between someone working as an employee and someone working as an independent contractor. Now, why are we looking at this? And the reason you have to look at the distinction between the two is because the legal costs associated with misclassifying individuals as independent contractors when they should be employees is quite significant. And what we're looking at is some of the biggest settlements of 2019 with respect to employment law matters and class action lawsuits. And what we see when we look at these various cases is that the misclassification and the attempt to appropriate or preclude the individuals from getting their full degree of wages, benefits, reimbursements, and other aspects that arises oftentimes with being classified as an employee and such that one is misclassified as an independent contractor are quite severe. So let's look at some of these high-level cases just briefly and show you what the consequences were. So we first address in Arizona the Van Dusen versus Swift transportation case, which resulted in a settlement of $100 million. And this was a case where drivers were misclassified as independent contractors, and thus the claim was that they were deprived of proper wages and reimbursements of expenses. So that litigation resulted in a settlement going towards those drivers who were reclassified for settlement purposes of $100 million. Next case we look at is O'Connor versus Uber Technologies, a California case. That one settled for $20 million. And once again, we have a drivers classified as independent contractors suing the company for that misclassification. The reason being that it enabled the company to avoid paying those individuals minimum wage and providing them with benefits. So that resulted in a settlement of $20 million. Then we take a look at Carter versus XPO Logistics, another California case settled in 2019 for $16.5 million. And once again, it's a delivery driver situation where they were misclassifying them as independent contractors and such that they were not getting minimum wage and overtime. And finally, if we look at the fourth case in this top 10 of class action lawsuits for 2019, we look at Alfred versus Pepperidge Farms, another California case, this time with respect to distributors in 3 states. And again, they were misclassified as independent contractors and as such were being denied employment benefits. And that settled for $22.5 million. Now, as we see from each of these cases, the underlying objective with classifying individuals as independent contractors is to minimize the expense burden upon the company. And naturally, from the individuals who are working for those companies, they find themselves working and not getting paid appropriately, such that these class actions are being taken against them, and they're fighting their classification as an independent contractor. Naturally, to push oneself out of independent contractor status requires that you meet the specific tests for the jurisdiction that you're within. And these tests can slightly differ. And it's not simply that the tests themselves can differ, but it's also the fact that the way the particular jurisdiction and the courts in that jurisdiction have litigated those cases and assessed those things relative to the factors that they look at, and also oftentimes other statutes that are particular to that jurisdiction, be it state or province, that demands certain aspects. So it's important to consider those points from the employer's perspective, that they're not misclassifying their individuals working for them as independent contractors when they are employees. And then on the flip side, for the individuals that are doing the work, consideration needs to be given as to, are you really an employee, and are you being denied the remuneration, the benefits, the other associated advantages of being an employee? And then it becomes a question as to how you deal with those situations. From the employer perspective, you're looking at possibly having to increase the cost associated with engaging those individuals as employees, and possibly having retroactive payments due to those people. That's the one consideration on the employer side. On the flip side, the employees are sort of challenged by this whole scenario, in that to go and challenge these large companies that they're working for, they risk losing their job. And they might well want to have that job. And how do they go about doing it? They might not well know the appropriate procedure, the process, how to protect themselves, and the negative clout associated with taking action against the company. Always a challenge. But it's a challenge that people need to consider, and they need to understand the specifics of what they're entering into and the factual circumstances that pertain to them. Because in certain circumstances, they might well have a solid and viable case. In other circumstances, the viability might not well be there. They might be overextending themselves to try to create a case where nothing necessarily comes out of it. Nevertheless, you have to look at all these various angles and see when an individual should be an independent contractor and when that classification is inappropriate and they should be treated as an employee, and how to proceed with those scenarios. I trust you found this YouTube video informative. If you're looking for us to address these matters, please do not hesitate to contact ourselves and find out how we might well be of assistance in proceeding down that particular avenue. I thank you for your time and look forward to speaking with you again.